still remain with the president? And there are a number of other questions, even as we wait for the plenary to raise questions by raising of the hand, to which point the microphone will be given to you. But we have Kennedy Owidi, who says that given the challenges and the events that have transpired in the past 10 years of our Constitution, can we really say that the Constitution embodies the spirit of the nation? Professor Pielo Lumumba, Stanley Kinyanjui would like to know whether, as we strive to ensure the independence of the commissions, it is important to note that they do not have, to date, an enforcement mechanism of their decisions. Turning to the courts for adoption of such decisions as enforceable using the judicial mechanism is also a frowned upon practice. Given that law does not exist in a vacuum and that orders should never be in vain, what do you then suggest should be the practice? Should their functions stand suspended until the enforcement mechanisms are put into place? Karen Wahungu, question to Honorable Lady Justice Dr. Nancy Baraza. Is it her suggestion that we consider another means to achieving greater representation of women in politics? Looking at the various bills that have been presented before Parliament and the inputs of different scholars as well, does the answer lie in the strict adherence to the implementation of the two-thirds rule, or should we look into other methods that will lead to the achievement of equality progressively? I think I'll give us just two more, and then let's see whether we have any hands raised, barring which I will come straight to the panelists. Is there a need to focus on issues that are more related to processes affecting delivery of services to the people, such as revenue allocation and public tendering, since the failure of executive and legislature in these aspects puts the judiciary under extreme pressure to do more than interpretation? And finally, from this segment for now, let us take this one by Abel Odongo Onyango, who says that constitutionalism in its complexion requires adherence to the Constitution and its principles. Constitution being the constitute of the instruments of government, it is therefore criminal for the government constituted by the same laws to blatantly disobey court orders directed by the courts, of course. What is the way forward? What can be done for this regime to obey the fundamental law of the land? And what are the legal, philosophical, and jurisprudential concepts in the modern level views of law to deal with such situations? I think that is quite a plateful. Before we pass the microphone around, could we have some responses to that? Perhaps beginning with you, Professor Pielo Lumumba, followed by Lady Justice Baraza, responding to the more specific questions that have been pointedly placed at your doorstep. Then we'll come to the other honorable panelists. Thank you.
Thank you very much, Barack. Let me, before I answer the question, invite the participants to read a very important document. This is a document that was generated in the month of September 2016 by the then Auditor General. The working group was appointed by Parliament on the 26th day of February 2018, and it mandated the Auditor General to undertake a socio-economic audit of the Constitution of Kenya 2010. It's a very rich document that speaks to quite a number of the issues that we have raised here as regard the impact of the Constitution. But now to go back to the question that has been posed to me, first, when we talk about constitutional implementation, we must remind ourselves that the Constitution in and of itself, and Professor Muigai has spoken to it, is not the magic wand. There must be a culture of respecting the Constitution. And that is what made my good teacher, the late Professor Hastings Wilfred Openyoko Thogendo, to say there are constitutions without constitutionalism. So that culture is what we have yet to embrace. And that is why you see the executive arm of the government with very jaundiced arguments, ignoring clear court orders. It is going to take time, particularly when there is no culture of respecting these orders. But it is incumbent upon the judiciary to make findings that indict the executive when they don't obey court orders. And in the fullness of time, the culture will indeed begin to gain root. And as the Honorable Judge Odunga said, if the people are vigilant and they make demands of the political class, then they will begin to obey these court orders. The second issue that has been asked of me is the ability of Chapter 5 commissions to implement some of their decisions. The Gender Commission, the Commission on National Cohesion, which is not a Chapter 5, but in that class. Then you talk about the Ombudsman. There is a danger to give every other body what one may call executing powers. I hold the view that these institutions exist in a legal environment. First of all, I hold the view that the commission should be reduced, as my good friend, Professor Muigai said. And once you do so and you create clarity in what their functions are, you will find that they will function. Take, for example, an argument that I personally did embrace at one time, that ESCC needed prosecutorial powers. There may still be merit, but if you look at the intimacy with which the ESCC is now working with the ODPP, you can see how institutions can begin to consummate their relationship in a manner that allows them to work seamlessly and effectively. And I hold the view that this is not a matter of constitutional architecture, it is a matter of constitutional practice, which will bring out a culture that allows us to operate. I conclude by giving the example of Sweden. The institution of the Ombudsman, which we borrowed from Sweden and which Sweden has given to the world, works seamlessly and effectively in that country because the culture is a culture of obedience to constitutional prescriptions. And I believe that we will get there. We are still a young constitution, and I can't agree more with Judge Odunga that as we go, we'll make baby steps, and you'll have people who belong to Egypt, and therefore they'll always want to take us to the flesh pot of Egypt. And it is our duty to tell them that we are headed to the promised land. But there will be many dangers in the desert as we sojourn and as we are headed to the promised land.
Seem to make, thank you, Professor Pielo, but do we seem to make one or two baby steps forwards and a couple of giant steps backwards? One is particularly thinking about disobeying court orders. And is culture enforceable without necessarily getting the people's vigilance to turn into the denomination of street protests? Are there alternatives of the eternal vigilance that we talk about? Or should we give up and perhaps vary the Constitution itself to remove some of the things that we would seem to be unable to achieve? We have had a question here given to Lady Justice Nancy Baraza about her suggestion whether we should consider another means of achieving greater representation. I think she can read it there on her screen. Lady Justice Dr. Nancy Baraza. Are you with us, Honorable Justice Nancy Baraza? Have we lost you? I don't see.
As you are looking for her, somebody has posed the question, Juliet, asking about the document that I mentioned. This is the report of the working group on the socio-economic audit of the Constitution, which was published in September 2016 as a result of the parliamentary mandate given to it on the 26th of February 2014. It was chaired by the then Auditor General, Edward Ouko, and you can find it indeed if you Google. If you can't find it, I have a hard copy.
Very good. Professor Githumu, could you speak to the questions that have been raised? And one is particularly concerned about talking about culture. Culture seems to be something that becomes entrenched and whose reversal can be very difficult. How do we get ourselves out of that quagmire of a culture of defiance, defying the court, when the court would, in our view, be what you'd call the last firewall? Professor.
Thank you very much. I think my contribution to that particular debate would be on the topic of civic education. For a man who has spent the better part of my professional life working in or around the Constitution, teaching it, writing it, arguing cases about it, I am most proud of one thing. I think that not only on this continent, this is not an African issue. Kenyans are among the most informed populations about these political questions. And I think that, as you are aware, many foreigners comment about the level of political discourse in Kenya and the sophistication of political discourse among ordinary people, not around politicians, are among ordinary people. I think this has been a product of the debates that we've held around the Constitution, around the first referendum, around the second referendum, and around the new issues that are facing us presently. If we haven't won anything else, we have won this, that Kenyans are aware, they are engaged, they are informed, and therefore for me, I live in hope that what my distinguished comrade PLO calls, I think taking from Judge Odunga, the baby steps. These baby steps are critical and they give me faith, and I have no doubt that a culture is coming and there's a cultural change. And I tell my students that I take great solace in the knowledge that there are things that in the constitutional debates in Kenya are no longer on the table. They are no longer on the table, meaning we have fought about them, we have fought over many years about them, and we have resolved them, and we have decided this is not on. There can be no discrimination on the basis of religion, of ethnicity, of et cetera, et cetera, et cetera. Some things we've removed completely from the table. And I think that that is important. Other things we have put permanently on the table and said we will continue to fight and debate about this issue until it's resolved. Equal distribution of resources, equal access to development. That issue is permanently on the table. There are many countries in which all these are taboo subjects. I call that a victory for our generation and for this constitution.
Very good. Indeed, Professor, I agree with you. We have seen the evolution of that which is called Bunge la Wananchi, and you find Kenyans assembled in street corners and other conjunctions where they discuss political, social, and economic issues of their country. Kenyans have that opportunity to ventilate. Is that ventilation translating into something tangible over and beyond awareness? We have seen that when we talk about civic education, some of those who have played a key role in the past have been civil society. But have we also witnessed during this dispensation of the Constitution of Kenya 2010 an effort to demonize civil society and its work, and in fact to use such pejoratives as evil society? How do we ensure that we do not reverse and negate the gains that have been made? Justice George Odunga, as you also tie that up with the questions that have been raised, before we go back to the panelists, if we will not have discovered the whereabouts of the Honorable Justice Lady Nancy Barasa.
Thank you very much, Chair. Without dealing with the specifics, defiance of court order is really unacceptable. The principle of constitutionalism requires that we adhere to the rule of law. And the rule of law requires us to obey the court orders. We have avenues for challenging court orders which we are unhappy with. We may not agree with all the orders given by the court. And those orders may not necessarily be correct. But there's the option of disobedience of court orders is a no-go zone. So I think we must be clear about that as a country, as a democracy, as a country that prides itself to be guided by the rule of law and the Constitution, we have no option but to comply strictly to the Constitution of Kenya, because this is the document that the people of Kenya promulgated to be a bridge between them and the people who govern them. I really do not want to talk much about the civil society. As such, I have myself made certain decisions on cases that have come before me, which have been brought by the civil society. And I don't think it's a matter where I need to really give an opinion on here, since some of those matters might still be finding their ways in the ladders of justice.
Indeed, we appreciate those limitations that are some of the issues that we may want to talk about being presently processed through the courts, and therefore we may not want to go overboard. I want to apologize that we seem to be having a slight hiccup with the microphone, and therefore we will request that we continue to populate the questions and the discussion platform with our thoughts, and we will do our very best to give as many of the participants as possible the opportunity to speak. Try to telescope the comments so that we do not take too much time, and even as I recognize that I'm myself taking quite a bit of time in my interventions, which I'll try to keep short. Anungo Kavele says that one Duncan Kennedy held the opinion that politics and the law are indivisible. Based on the past, clearly politics have played a crucial role in the development of law in the country. politicians have played a huge role regardless of their knowledge in matters law. And he would like the panelists to address the effects of the politics of the day on the judiciary functions, on the judiciary's functions with regard to Article 160 of the Constitution, whether a people elected rather than an executive appointed judiciary would be more independent, and the role of an independent judiciary in the realization of the dictates of the Constitution of the day. Quite a complex question there, but I have no doubt the panelists get it. All panelists, Chapter 6 is not just any other chapter. However, don't you think that Article 52A on the right of an accused person to be presumed innocent until proven guilty slows down the pace to realize the essence of Chapter 6 of the Constitution? And if so, how can the two be reviewed and harmonized to ensure that Chapter 6 is not rendered to be a mere chapter in the supreme laws of the land? I give you 2 minutes each on those questions. PLO?
Very quickly, the question about Article 160 on independence of the judiciary. There is a very interesting comment that was made by Dan Wadada of Uganda, who is a legal luminary. He was commenting about a statement made by a young lawyer called Picho Ali. And this is what he said, that when all is said and done, I agree, and we all must agree with Picho, that there is nothing like independence of the judiciary, that the so-called independence of the judiciary is nothing but division of labor. Of course, I don't agree with that, Justice Odunga, but there is a sense in which a judiciary does not exist in a vacuum. And I can't agree with you more that if a country disobeys court orders, then that country is a giant headed to the rocks. And that is why it behooves the judiciary, when orders are disobeyed, to cite these individuals for contempt, even if you cannot send them to jail. But let the record show that the individuals were visited with some pain known to law. The second question that has been posed is about presumption of innocence. I can never, ever allow, if I'm the one to be allowed, to depart from that. It is easy to say when your neck is not on the chopping board, but it is incumbent upon us to recognize that presumption of innocence is critical and a major plank in a country that is governed by the rule of law. Perhaps what we can do is to expedite hearings so that people are punished expeditiously if there is available evidence against them. And thirdly, Mr. Moderator, somebody has posed the question about the basic structure of the Constitution. And I think it is the Indians who developed this concept very robustly. You will see in our own Constitution, there are entrenched provisions. And these entrenched provisions actually are teased out of the concept of the basic structure. And that is why amending them requires the people's involvement. But very lastly, I want to agree with somebody who is saying that you cannot legislate good behavior, but the law does limit the bad behavior. And if bad behavior is limited by the law, in the fullness of time, mannerless individuals will begin to behave in a manner that is correct, and ultimately we develop a national culture. And in 150 years' time, you will be amazed. Remember when Abraham Lincoln proclaimed the freedom of the slaves. Until 1963, people of color did not have freedom in the United States of America. It takes time. It is intergenerational. And what we are doing now is to play our part and to hand over the baton. What we don't achieve now will be achieved by our children and children's children. But let us play our part robustly.
Proclamation of Emancipation, 1863.
Indeed. And 100 years, you remember, Luther King Jr. was still campaigning against the laws in Alabama.
Okay, so is it okay that we should just be satisfied that we're making those baby steps. Justice George Odunga, you are 2 minutes, and then I think now the microphone seems to be working, and we will give our other colleagues the opportunity to be heard. But first, over to you, Honorable Justice Odunga.
Thank you very much, Chair. With respect to the issue of politics and law, there's a way in which you can say that these particular principles are intertwined. If you look at what I call the structural interdict, these are remedies which are mainly in the socioeconomic sphere, where, for example, you are dealing with the right to adequate food. You know, these are not the kind of matters you can deal with and give a judgment and stop there. Because there may be a need for you to also take certain steps to ensure that your judgment is implemented. And therefore, it might be necessary, even after you deliver your judgment, to engage the other arms of the government to ensure that the decision that you've given is being implemented. And in that way, you can say that you cannot completely divorce law from politics, because as you make your decision, those decisions are going to be implemented. Some can be implemented immediately, some require to be implemented over a period of time, hence the need for supervision.
Indeed, particularly in a context in which we start developing thick skins and we become indifferent to the phenomenon of public opprobrium and the possibility that we lose all capacity to feel ashamed, and society itself loses the capacity to ostracize those whom we would clearly call miscreants and reprobates and other serial law breakers. But we have got back Lady Justice Nancy Baraza. Could you speak to that question of alternative ways of ensuring that we achieve gender parity in institutions, whether it's appointive or elective? If you are hearing us, Lady Justice Nancy Baraza?
I'm hearing you, sir. Sorry, I went off power. I've just come in. Just refresh me a little. I'll deal with the question.
Chair, you are mute.
You are mute, Chair.
That is a cardinal sin by the chair. May the chair be forgiven. But Justice Baraza, the suggestion was made by yourself that another means of achieving greater representation of women in politics be considered. And we've been told that Parliament has made various efforts, but they have fallen through invariably. And what then would these other alternative means be? And additionally, Lady Justice Nancy Baraza, without wading into dangerous spaces within the presence of the principle of sub judice, Parliament has made numerous efforts, as we are aware. Is it such a sinning institution? Can we condemn it wholesale? Over to you.
Thank you very much, Chair. I think for me the problem has been political will to push through legislation for realization of gender parity and gender equity in public participation. It is true, quite a number of bills were presented to Parliament, but then achieving the constitutional number to push through the legislation has been a problem. So that some members of Parliament decide to absent themselves when the voting comes or the debate comes, and that has been a problem. I think it is the attitude that Parliament has had towards gender empowerment. The debates themselves display quite a lot of negative thinking about empowering women in politics, in Parliament, in participation. So unless we do probably a lot of civic education to educate would-be members of Parliament and the members of Parliament themselves to realize that realization of the not more than 2/3 gender principle is a constitutional requirement, which they treat as if it isn't. So first and foremost, most of them do not appreciate their role in Parliament. Most of them do not appreciate their obligations under the Constitution. So the problem is larger than just having those bills in Parliament. Most of them haven't come to terms with the fact that that principle needs to be realized. And that is why, Chair, I was hesitant, quite apprehensive at first, that if we take this whole question of the not more than 2/3 gender principle back to the people who may not have the benefit of civic education, then it might be lost altogether. If we get parliamentarians who are under an obligation to enact that legislation, behaving the way they have behaved, then what would an ignorant public do? So the problem is large, but if there is political goodwill, we can still get a framework for realization of that principle.
Before I go to the plenary, I think I must bring this into Professor Githu Muigai's courtyard. Professor Githu Muigai, you have had the onerous task of advising the political class, particularly on this issue. Is it a matter possibly of feelings of impunity, feelings of, so what will anybody do about this? Is it true that there is inadequate goodwill and by extension, therefore, impunity in Parliament because they don't believe that anything could happen to them? Professor.
Let me first start with the question of law and politics. All law implicates politics, but constitutional law in particular implicates politics in a very fundamental way because the Constitution is a power map. It is a map that is drawn to distribute power. Power is ultimately about politics. So I think we should put that to bed, that we shouldn't worry too much if politics and law seem to have intersections. They are congenitally, that's how they were intended to be. And that is why the Constitution, that is why in a constitutional democracy, you have provisions like the chapter on the Bill of Rights, etc., because they are intended to ensure that politics doesn't become a zero-sum game. Let me come to this very controversial question, which ordinarily I would not wish to wade into. The question of the observance of court orders. I think there are two sides to that coin, and one side has been spoken about, and I need not speak about it. But there is another very fundamental debate that we need to have. The more robust the judiciary became, the more the firmer and more independent the judiciary became, in my opinion, the more it overreached in some key areas. Judicial authority all over the world exists because the judiciary is respected as impartial, independent, and unimplicated in raw politics or policy. Now, increasingly, for better or for worse, our own courts have moved further and further and further into the political arena. And you have now every day, it is in my time, when we were students, it would have been totally unheard of that a case can be filed where the question is, the Minister of Transport has determined that the optimum matatu on a Kenyan road should have a minimum of 18 passengers. And the court has said, no, Mr. Minister, why don't we make it 9? You see, that is not a judicial, it is not a matter amenable to judicial interventions. Unfortunately, there are many, many matters now where you find judicial intervention in policy/political matters, creating this contestation. Now, I don't hold brief for either the judiciary or for the politicians, but it requires all of us, especially the scholars, the academics, to begin to debate what are the proper parameters of judicial intervention. Not every grievance is amenable to judicial resolution. My neighbor looked at me in a hostile way. It's not a justiciable matter, and you cannot get an court order that directs your neighbor on how he should be looking at you when you meet at the gate. So I hope I don't trivialize that, but it is a real important part of this debate that is not being heard.
Thank you very much. I've heard that in certain jurisprudences that how you look at somebody could actually get you to be jailed by the courts. But Justice Odunga, we will be coming to you. Just put this in the parking space because we'll give you the first opportunity to speak when we come back. Put this in the parking yard. Is the judiciary overreaching itself? That has come from AG Emeritus. We will be coming back to you. I'd like to request the participants to raise your hand so that you can also be heard. I think we can see your hand here. Mamu James, I allow you to talk. Mamu James. Yes, Mahmoud James.
Yes, good afternoon.
Good afternoon.
Now, I agree with Professor Gidi Wigai that perhaps the issue of public finance was not considered. If you look at the public debt as at June 2010, it was about 1.2 billion. That is 39% of GDP. And now this year, the public debt has risen to 6.7 trillion, which is 65% of the GDP. Now, my question goes to Professor Patrick Loch Lumumba. Now, having been the secretary of CKRC that majorly midwife the Bomas draft that this constitution has borrowed from, don't you think that CKRC should take responsibility for a part of the problem that we face in terms of financing this constitution? The next question goes to Professor Gidi Wigai. If you look at the issue of the disobedience of court orders, the Attorney General is at the center of the storm. Don't you think that there was a mistake in including the Attorney General to sit in the JSC as a member of JSC, because he finds himself sometimes in a very conflicting position? Don't you think that if, for example, the BBI movement succeeds, that we should remove the Attorney General as a member of Judicial Service Commission and perhaps have another government officer sit there, but not the Attorney General, because he advises the President and he also advises the Chief Justice when he comes to the Judicial Service Commission. Thank you.
Chair, you seem to be mute again.
Yeah, it's mute. I don't know whether it's mute or malice.
I was brought up in a muted environment. Sometimes I find myself muted.
Can I respond to them?
Let's take David first. I think he has the microphone now, if I'm not wrong. David Lesinko?
Yeah.
Over.
Thank you very much. My question is with regard to the basic structure doctrine and whether the framers of Kenyan 2010 Constitution really did envision the basic structure doctrine, because it is my understanding, and Justice Odunga just quoted Article 1 of the Constitution on the sovereignty of the people. And my question revolves around amendment of the Constitution by popular initiative. It's my own argument that the people are the sovereign, and whenever issues of amendment of the Constitutions through a popular initiative arises, then throwing the ball back to the people who are the sovereign should not really raise a lot of questions, because the people can decide to amend the Constitution if they deem fit. In that regard, is it therefore a justiciable question for one maybe to approach a court of law seeking advisory opinion on such a matter? Because I don't think you can really challenge amendment of a constitution by a popular initiative, because we understand that the people are the sovereign. Thank you very much.
Good. Let's take one more. Belinda Akello. Belinda Akello, can you hear us?
Okay, now I'm able to unmute. Thank you very much, Mr. Muluka. So very interesting conversations, and I'll just steer a little bit away from politics and ask, with the theme of promulgating the new constitutions, one of the new areas the Constitution 2010 has brought is the elevating the threshold of environmental matters to a constitutional level. Now, the judiciary has been a bit disappointing in trying to make new environmental jurisprudence, but around the world, constitutions that have actually adopted this kind of elevation have also gone ahead to give rights to nature, and have also been of the opinion from some that human beings are having too many rights. So nature should also have rights and value. I'd be very interested to hear from Professor, from all the panelists actually, on what your take is about the elevation of environmental issues to a constitutional threshold. Should it have been there? Should we remove it so that it's just a statutory matter? And maybe also from the Honorable Lady Justice, the role of women in appreciating environmental matters, and particularly at a constitutional level. Are we doing justice? Or maybe it's something that we should review in BBI and have it removed? Or for all the panelists again, as the other countries have done, should we also give rights at the Constitution, or go the Ugandan way and just give rights of the environment in statutes? Thank you.
Very, very good. Environmental issues, environmental rights. Let's get back to the panelists, and I did promise that we would go back to Justice Odunga to unpack that question. Then we'll come back to the rest of the panelists on the rest of the array of questions that have been raised. Justice Odunga?
Thank you very much, Chair. The issue of the judiciary overreaching itself, this is basically what I meant when I was talking about the tough wars. when you have the kind of constitution that we have, the Constitution of Kenya 2010, that is definitely different from the other constitution, the one that disperses power among different organs, the judiciary, the executive, and of course the commissions. You expect to find a situation where some organs might not be very comfortable about the manner in which particular organs are exercising their mandate. You may also find that certain organs may actually be moving a little bit beyond their mandate. That's very possible. You can't rule that one out. These are situations which are expected.
Those institutions, Justice Odunga.
Yes.
Is the judiciary one of those institutions that could be gravitating beyond its mandates?
It's not very easy to say that the judiciary is getting beyond its mandate. Because you see, the thing is that you have to look at a decision, each and every decision, and look at it on its own merit. To say that the judiciary as a whole is getting out of its mandate may not be fair to the judiciary. However, the point I'm making is that with time, these organs are going to get their space. They'll know where their space is. The judiciary, the executive, and the legislature. It's going to take us some time, a bit of some time to do that, but we will be there.
Very good. Professor PLO?
Let me very quickly just advert to the environment question, which is one that is out of step. Then I come to James Mwamu. Belinda, you will remember that the question of environment has preoccupied the world since, the Stockholm Declaration of 1972 and the 26 principles. From Stockholm, we moved to Rio, to Kyoto, then to Paris. And even if you want to go outside of the fauna and flora and you go into the oceans, you go into the Law of the Sea Convention. There is a sense in which we must read our Constitution in the context of those international principles which really take time to be cascaded down. And I will invite you, if you're not already familiar with them, some of the great work that is being done by way of activism by Friends of the Earth in Europe. And I think go basically to Stockholm, and these are some of the things that I think our judiciary should familiarize themselves with. And I'll not go beyond that because of time. The second more specific question to me is the one that is posed by my good friend James Mwamu. James, remember that the CKRC generated a draft. And if you look at our draft, which is a draft of March the year 2002, that draft has very different provisions relating to public finance. Our CKRC draft was then debated at Bomas and produced the Bomas draft. The Bomas draft was converted into the Kilifi, sometimes eponymously referred to as the Wako draft. The Wako draft, then of course, as you know, we were removed at that time, and then we ended up with the 2007, and we ended up with the harmonized draft. The harmonized draft was also affected by the interventions of the political class at Naivasha. And what you have as Chapter 12, which deals with public finance now, is in many philosophical and fundamental ways different from the original prescription by the CKRC, which was very sensitive to the public debt. And one of the reasons why I think that this is very critical, look at some of the things that were prescribed. Number one, introduce Commission on Revenue Allocation. Deal with salaries through the Salaries Commission. Split the Office of the Auditor General and have control of budget. All these things were done in the belief that if you were on the ball all the time, then you would not allow Parliament to run amok in the manner that it has. And I know now, courtesy of COVID, Parliament will say, but we are dealing with extraordinary times. But I cannot go, sorry. I cannot go further than this because this is something that I think requires quite some time. But I believe I make myself clear by saying that the CKRC, like Caesar's wife before it, is beyond reproach in these matters.
Very good. Lady Justice Nancy Baraza, you have been specifically mentioned and requested to say something about environmental issues.
Thank you very much, Chair. Participation in realization of the rights envisaged in the Constitution is recognized, and therefore women, through policy and legislation, should be able to participate in environmental conservation. And of course, the right applies to everybody, and participation is envisaged by everybody. So I think that can be done through policy and legislation. I don't know to what extent that has been done. Environmental area is not my strongest, but I believe that women should be able to participate in matters environmental.
Very good. Honorable AG Emeritus.
I'm afraid I'm not very competent on the last topic of how environmental justice can be expanded, except to say that I have been working with the UN working group on business and human rights, and I know that there is increased awareness among businesses, and I think this is a very good beginning, because businesses are some of the worst environmental degraders in the world, especially extractives. But there is an awareness now that is gaining ground to get business to appreciate that they don't just exploit the environment, they are responsible for restoring the environment. And to that extent, I think that this is an interesting horizon that we in Kenya ought to be getting in tune with. Thank you.
Thank you very much, Honorable AG Emeritus. We have been allowed a few more minutes by Law Africa so that we could take a few more questions from the plenary. We'll take 1 or 2 rounds of questions, after which we will wrap up. And
Barack, if you permit me,
yes,
there is a question that has been posed, which I don't think we have spoken to, on the significance of Chapter 6.
Okay.
And just a single line, I think that Chapter 6 is critical on leadership and integrity. And I think we have not done justice to that chapter. And the Honorable Justice Odunga, this is the one area that I think a lot more